In this video, we will introduce the main commitments in the field of intellectual property under the Free Trade Agreement between Vietnam and the United Kingdom, or the UKVFTA. We will also compare these commitments with those under the Agreement on Trade-related aspects of intellectual property rights under the World Trade Organization, or the TRIPS. First of all, let us look at the main commitments. The intellectual property chapter under the UKVFTA inherits the majority of the intellectual property chapter under the Free Trade Agreement between Vietnam and the European Union, or the EVFTA. The commitments are categorized into two main types. The first one is general provisions and principles, and the second one is specific commitments. The specific commitments cover the following areas: copyright and related rights, trademarks, geographical indications, industrial designs, patents, protection of undisclosed information, plant variety rights, enforcement, cooperation and institution. Now, we will compare the UKVFTA intellectual property chapter and the TRIPS from three angles: obligation to join or to comply with international treaties, level of protection, and right protection measures, including civil and border control. Regarding obligation to join or to comply with international treaties, the intellectual property chapter under the UKVFTA requires parties to join three more international treaties compared to the TRIPS, namely, the Copyright Treaty under the World Intellectual Property Organization, or the WIPO, the WIPO's Performances and Phonograms Treaty, and the Hague Agreements concerning international registration of industrial designs. Regarding level of protection for patents, in addition to the standards as set out in the TRIPS, the UKVFTA introduces a higher level of protection, in which each party has to maintain a mechanism to compensate for patent owner if their application of pharmaceutical products for granting the first marketing authorization is unreasonably delayed. For trademarks, an outstanding difference between the UKVFTA and the TRIPS is the addition of a separate provision on trademark revocation, which focuses on three cases: the non-use period of the trademarks leading to the possibility of revocation in the TRIPS is at least 3 years. Meanwhile, this period is 5 years in the UKVFTA. The possibility of revocation if the trademark becomes the generic name of the product or service for which the trademark is registered. A trademark is protected, however, its use may mislead the public to the nature, quality, or geographical origin of those goods or services. For industrial designs, the UKVFTA imposes stricter requirements to protect industrial designs of products that are a component part of a complex product. It means, on the one hand, the former has to remain visible during normal use of the letter. On the other hand, the former also qualifies as an industrial design. For geographical indications, or GI, the TRIPS agreement only requires parties to undertake appropriate GI protection measures. Meanwhile, the UKVFTA requires maintaining a separate system of GI registration and protection with at least 4 elements in its processes and procedures. Furthermore, the UKVFTA, compared to the TRIPS, provides an additional mechanism to protect specific GIs. In particular, 2 GIs of the UK, 2 cross-border GIs of both the UK and the EU, and 39 GIs of Vietnam are protected in the territory of each party at a level equivalent to the protection level for GIs of wines and liquors in the TRIPS. Regarding right protection measures, first, civil measures. In terms of presumption of right holders, for copyrights and related rights, the UKVFTA requires that in the absence of evidence to the contrary, the persons named in the usual manner be the author, performer, producer, or publisher. For example, names on book covers, album covers, etc. are considered right holders and can take actions against infringement. In terms of compensation, the UKVFTA has more specific and binding prescription than the TRIPS on the obligation of the losing party to pay the costs for both the plaintiff and the defendant, instead of only for the defendant. In terms of right enforcement in the digital environment, the UKVFTA surpasses the TRIPS, since it adds provisions on disabling technological rights protection measures or changing rights management information. The RMI is also considered as an infringement and must be dealt with, even though this is in essence just the premise of the infringement. Regarding border enforcement, in terms of scope, the UKVFTA requires border controls on both imports and exports. Meanwhile, the TRIPS agreement imposes border control measures upon request of right holders only on imported goods. In terms of objects, the TRIPS stipulates that border control applies only to counterfeit trademarks and copyright infringed goods, while the UKVFTA extends to counterfeit GIs. Through this video, we hope that you now have better understanding about intellectual property commitments under the UKVFTA. For further information, please contact us via appropriate mailbox or phone number displayed on the screen. Thank you.